clients often ask us, if I go with a nomination, what's my obligation? Do I have to live in Ontario forever? Do I have to live 1 month, 1 year? Is there a minimum requirement? And I always tell the clients the same. It's basically, if you take this nomination, if you take advantage of this opportunity and want to apply under Ontario, and later apply for permanent residence as a provincial nominee, you're making declarations in writing. You're signing to both Ontario and IRCC, meaning the federal government, that you're committing to settling in Ontario. However, if later on you arrive in the province to settle, but you can't find a job and you find a good job elsewhere, you can move there. You have the same mobility rights as any other Canadian permanent resident. If your wife, for example, is accepted to a PhD program in a different province and you want to relocate, you can do that. All of that is fine. And there's no minimum period that you have to live in the province before taking that next step. What's going to happen eventually, though, is that you may want to apply for Canadian citizenship, or you may have to renew your permanent resident card. And when you do that, you don't want to be in the situation where the government notices that you applied for permanent residence as an Ontario nominee, but you now live in Alberta, for example. And they could potentially start an investigation to make sure that you didn't lie or that you didn't misrepresent your original intention to live in Ontario. Even though, to be honest, I do find that such investigations are very uncommon. So the best way to fight that or to respond to any allegation of misrepresentation is to show, well, look, I arrived in Ontario, I registered my children in school, I rented an apartment, here's the lease, I bought a house, here's the property title, I looked for jobs and here's evidence of my emails to prospective employers. My wife and I went to a settlement office, we met with a settlement worker, and here's evidence of that and the emails that we exchanged with that settlement worker. So as long as you can show that it was your intention to settle there as planned and that you made efforts to do so, that's fine if you ever do find yourself in that wrong side of an investigation. But I do tell clients from the beginning, if you're telling me right now that you in fact do not intend to settle in Ontario or the province that is extending you the opportunity to apply for the nomination, and that you're going to be settling somewhere else in Canada, then I have to tell them that I can't work with you. Because what you're going to do is to lie in an immigration application. You want to misrepresent your intention, and I'm not helping you with that, and I'm not putting my signature in that application. But if the client intends to give it a try and plans to settle in the province that will be nominating them, then that's fine. If they eventually need to move somewhere else, then as long as they keep evidence of all the attempts that they made to settle in Ontario, that's okay. There's no requirement to reside in the province for a minimum period of time after they land as a permanent resident.